welcome to my first video blog. I got the idea to do this a few days ago when I did a rather silly Ringo Starr impersonation video, which you may or probably may not have found amusing. Anyway, that got me thinking maybe I could do something serious on a video, so this is my first effort. All I'm going to be doing is referring to some stories from family law from the past week, or family law blogs from the past week. I hope you find it of interest. I've called the video The Week in View, which is my little joke, which is probably not a very good one, but anyway, here goes. Oh, and by the way, the links to the stories I'm going to mention are, or should be, down there below this video. Right, the first thing I'm going to mention in this video is the case of Whitehouse Piper and Stokes that I posted about earlier in the week. I'm not going to go into details of the facts of the case, but basically there was an agreement way back in 1997 between the parties that the wife would transfer her interest in the matrimonial home to the husband for no consideration, as there was no equity in the property at that time. Unfortunately, the mortgagee didn't agree to the transfer, and it was never implemented. Some years later, 2005, by which time the house had an equity of £80,000 to £90,000, husband tried to implement the transfer, and the wife responded by issuing an application for ancillary relief. The district judge did order the transfer, but refused to grant her lump sum. She appealed ultimately to the Court of Appeal, where Lord Justice Thorpe again rejected her appeal, and also dealt with a point which had been raised by the circuit judge, who was concerned that the wife was seeking an order against herself. Lord Justice Thorpe pointed out that she had included all forms of ancillary relief in her petition, and it's well established that this entitled her to proceed with an application for ancillary relief, notwithstanding her remarriage. And the case of Dart and Dart made it quite clear that she was also entitled to seek an order against herself. As I say in the post, nothing really new in this case, but certainly a warning to anyone who's seeking to reopen an agreement. Not only did the wife fail to get her lump sum, but she was also ordered to pay the husband's costs. Right, the next thing I want to talk about is the Madonna and Guy Ritchie separation and presumably divorce. The biggest story of the week, and probably of the year. Well, there's already been a lot of sensationalist nonsense about this case in the media, and no doubt there's going to be a lot more. So I did a post earlier in the week concentrating on the serious legal issues, of which I came up with 4. First of all, most importantly, the children. I said in the post that hopefully Madonna and Guy Ritchie can sort out arrangements for the children by agreement, even if they can't sort anything else out by agreement. As we all know, all family lawyers certainly know that a contested application relating to children is a disaster for all concerned, especially, of course, the children. There is one other particular point, and that is the question of whether or not Madonna intends to take the children with her to the USA. If she does, then she'll obviously either need Ritchie's agreement or a court order allowing her to do so. Okay, the second point that I mentioned was the issue of jurisdiction. A lot has been made about this. As we all know, nowadays or rather London is considered to be the divorce capital of the world, and it has certainly acquired a reputation for being extremely generous to the poorer, in inverted commas, spouse. So the speculation is that perhaps Madonna might be better off issuing in America. Well, we'll have to wait and see, although I do note that she's instructed, or apparently instructed, Sir Paul McCartney's legal team, including Fiona Shackleton, which suggests to me that perhaps she's going to issue in this country. Third point was whether or not there's a prenuptial agreement. We don't know, but if there is, then if the proceedings are in this country, then it's likely to be of less relevance than if the proceedings were elsewhere. The position in this country is quite simply that prenuptial agreements are not binding upon the court. They're just one of the factors to be taken into account, and for what it's worth, my view is that in view of the length of the marriage and the fact that there are 3 children, I somewhat doubt that an English court would give it that much weight. The last point I made is regarding the settlement itself, and well, there's been a lot of speculation that this could perhaps even be the largest settlement in British legal history. Well, I'm not sure about that, but the point has been made, and I think it's a good one, that this case can be distinguished from the McCartney-Mills divorce, in which virtually all of the assets were accumulated or acquired prior to the marriage. So the speculation therefore is that Ritchie will be entitled to a substantial settlement, substantially more, that is, than Heather Mills was awarded. Again, we'll have to wait and see, though I do note that it's been reported that Ritchie has said that he doesn't want any of Madonna's money. Well, again, we'll have to see. Mention is from the ever excellent Bloody Relations blog, where Jackie Gilliatt did a post this week about the habitual problem of drink, which is so often a problem in relationship breakdown. I'm not going to go through the post in any sort of detail, it's not my post, but I would recommend that you have a read of it. Jackie gives some very useful advice, I think, not just for those dealing with these cases, but for those involved in them as well. Have a look at the post. The last story that I want to mention on this video is one that appeared on the Pink Tape blog earlier in the week, and it's about the so-called turf wars between barristers and solicitors. I did mention this briefly in a short post on my own blog, but Lucy Reed at Pink Tape has gone into substantially more detail, and she, as I suppose one would expect, mounts a fairly robust case for the bar regarding the response of the Law Society to the family graduated fee scheme. Well, have a look at Lucy's post. I'm not going to comment on it, I'm on the other side of the profession, but the only thing I will say is that let's just hope that this is resolved pretty quickly, because the last thing we want is to be fighting amongst ourselves. I think all lawyers should be presenting a united front when it comes to legal aid. Okay, that's the end of this video. I hope you found it interesting, and please have a look at the stories that I've mentioned. As I say, the links to those stories you'll find below this video in this post. Goodbye.